Greetings, class. I'm sorry. My name is Carlos Paez, and today I'm going to be discussing Brennan's Inc. versus Dickie Brennan and Company Incorporated. So to begin, this all started with Owen Brennan, Owen E. Brennan Sr., who in the 1950s opened Brennan's Restaurant. Okay, at the time of his passing, 60% of the restaurant was given to his widow and his three children, Owen Jr., James, and Theodore. 40% went to his aunts, uncles, and brothers. Amongst the brothers was Richard Brennan Sr. He'll be relevant later. When that occurred, the Brennan family actually registered the Brennan name as a federal trademark and decided to open more restaurants. But there was ultimately a disagreement between the two sides in the early 1970s, so they decided to take legal action. In 1979, there was a legal settlement that decided that both sides had rights to the name, but the 60% side, including the widow and the kids, would have exclusive rights to any Brennan restaurant in Louisiana and all other states except for Texas and Georgia, where the brothers, aunts, and uncles side had exclusive rights to those restaurants. Specifically, the agreement further provided that, with some exceptions, no party would open or operate a new restaurant in Louisiana using the Brennan name, though the agreement also allowed the parties to aid their descendants' efforts to own or operate restaurants under any name. Regarding future disputes that might arise, the 1979 agreement stated that neither side would assert its trademark rights against the other for uses permitted by the agreement, but it also said that it did not bar future claims that might arise out of a breach agreement. Eventually, the widow passed away, and the sons, they took over that 60% side. Now, in the 1990s, Richard Sr. had a son named Dickie, Richard Jr., but his nickname was Dickie, and he decided to go into the restaurant business as well. So Dickie introduced a location called Dickie Brennan's Palace Cafe Restaurant, and eventually he opened Dickie Brennan's Steakhouse in New Orleans. So in July 1998, the brothers who controlled the 60% decided to have a conversation with Dickie about, to have an agreement about what they're going to do with the name. But when that happened, the brothers later mentioned that Dickie actually he concealed from them that Richard Sr. had ownership interest in the two restaurants with the Brennan name, which kind of breaches the contract from 1979 saying that they could aid, but he's technically involved. So but anyway, the original Brennan brothers, when they discussed what Dickie Brennan can do, they pretty much came to this conclusion. Dickie the Dickie Brennan name can stay on the steakhouse and the cafe, but Dickie could not use the name Brennan separately from Dickie. The words Dickie Brennan were not made more, and those two words, Dickie Brennan, could not be made more prominent than the rest of the name, which would be, of course, Palace Cafe and Steakhouse. And he also couldn't use specific typefaces, and Dickie did not and that their restaurant that Dickie restaurant didn't imply any connection to the original Brennan restaurant. So those were the specifics. The names had to be together. They couldn't be more important than the rest of the restaurant, and that it had no relation to the other Brennan restaurant names. So that was the agreement of 1998. After a few years, Brennan restaurant employees overheard guests saying that the Dickie Brennan restaurant, they thought it was related to the Brennan restaurant. So the brothers, they wanted to have a discussion with Dickie about that, because they felt that it was in a way breaching the 1998 agreement, which stated that it couldn't be related to the original restaurant. So they they had a meeting about it, but no one, they couldn't come to settlement. So the brothers decided to sue him and stated that he breached the agreement. So they, of course, had a counterclaim. You know, the defendants had a counterclaim stating that the steakhouse and the Palace City Cafe were actually the Palace Cafe, I'm sorry, were actually owned and operated by Cousins Restaurants Incorporated and 716 Iberville, stating pretty much that they had no relation to the Brennan Cafe, the Brennan original restaurant. So that was their counterclaim. And eventually, after it was taken to the court, this is what the court decided. So one, it said Richard Sr. had breached the 1979 agreement by owning a minority share of Cousins and 716 and otherwise contributing to those businesses. According to the district court, Richard Sr.'s activity amounted to contractually forbidden opening or operating of a restaurant, not the aid to a descendant permitted under the agreement. 2. The 1979 agreement barred the plaintiffs from bringing trademark-related claims against Richard Sr., which was stated before that they couldn't bring trademark argument against Richard Sr. And also they decided from the 1998 agreement that the Brennan brothers could not bring any trademark argument against Dickie Brennan. And lastly, Cousins and 716 could exercise the rights given to Dickie under the 1998 agreement, and so the plaintiffs could not pursue trademark-related claims against those companies either. As a result, the court affirmed that the district court's judgment, insofar as it rewarded $250,000 in damages plus interest and costs to the owners on its breach of contract claim, and it affirmed that district court's denial of the owners' motions for judgment as a matter of law or for a new trial on their fraudulent inducement claim. And the court reversed the ruling that an agreement barred the owners from pursuing trademark-related causes of action and remanded. And that's the case. That's the overview of the case, and that's the result. Thank you.